So today I want to talk about the importance of removing the due on sale clause from seller wrap financing and the proper disclosure to the seller that you're doing it. So every deed of trust as a standard clause or mortgage is going to have a due on sale clause, or some people call it an alienation clause, which basically says, look, if you borrower go and convey or transfer this property or do something else with respect to the property, sometimes it could be a long-term lease. You could even limit, the ability to provide an option, a contract for deed. But if you go and you convey an interest in the property and you do not obtain the lender's approval before doing that, that is an alienation that entitles the lender to come out of the woodwork and require that the full loan balance be paid. So that's called invoking the due on sale clause. So the lender has the ability to invoke the due on sale clause and require the full payment amount. Well, what about when you are purchasing a property subject to, and you're providing the seller with wrap financing, meaning you're committing to the seller and telling the seller, hey, look, seller, I'm going to make your mortgage payment for you. Or maybe the seller is carrying some of the equity and you say, hey, seller, I'm going to make monthly payments to a servicing agent or to you. And then we're going to use those funds to pay the lender and some amount to you. But we're going to keep your underlying loan in place. But the seller ends up with basically a second position mortgage or deed of trust on the property that secures your performance. You're going to pay their mortgage for them, basically, is what wrap financing states. And you make the seller a lender with the ability to foreclose on the property if you don't perform. Well, if you go and draft a standard mortgage or deed of trust, you're going to end up with a due on sale clause in favor of the seller. Well, what happens if you're an investor and you decide at some later date, well, I want to sell this property to somebody else, to an end buyer, and I want to sell it subject to, I want to leave the original mortgage in place. I want to leave the seller wrap financing in place. And then I'm going to sell it to this end buyer and I'm going to provide my own financing. So, you're going to sit in third position and provide your own seller carryback financing. Well, you can do that, but if the original seller had a due on sale clause in their wrap financing documents, they could come out of the woodwork and say, hey, time out. You can't do that. And so now you owe me the full loan amount. You have to pay off my loan, which would result in paying off the underlying loan against the property. And sellers may very well do this because there are times, and we see this over and over in our litigation department, where sellers have remorse. They enter into purchase contracts and they even close escrow and decide, oh, well, I don't want to do this subject to thing anymore for one reason or the other. Maybe they've spoken with somebody, a real estate professional who says, oh, you shouldn't have done that or whatever. It doesn't matter, but they somehow decide, I no longer want to do this transaction. And so they're looking for an opportunity to unwind it. So if you as the investor go and sell the property to a third party, or maybe even do a lease option, depending on what the due on sale clause states, the seller could then jump on that and say, oh, wait a minute, that's an alienation. Now you have to pay this off in 30 days. And if you don't, then I can foreclose and, take the property back. Well, you as the investor do not want that. So you want to make sure that you remove the due on sale clause. A lot of investors, when they do their wrap financing, they will have the title company prepare the deed of trust and the mortgage. And I will tell you, the title company's documents are going to have that due on sale clause in there. And you need to make sure to have that removed. But prior to having that removed, you need something in writing from the seller authorizing the removal of that clause, because that is a standard clause in a deed of trust or a mortgage. So you need to either have a subject to addendum that states expressly within that subject to addendum that the mortgage and deed of trust will not have a due on sale clause and have the seller initial, so that, there's no question that they were, given fair warning. They were advised that the wrap financing documents will not have a due on sale clause. Or if you didn't use a subject to addendum that has that provision, then you should have some document, some addendum, some acknowledgement that you submit at closing to have the seller sign off on and acknowledge that they understand that the documents being provided for their protection, putting them in second position on the property, is not going to have a due on sale clause. And then you need to make sure to have that due on sale clause removed. If you don't do that, you run the risk that if you want to use a disposition method of a subsequent seller carry, an agreement for sale, contract for deed, or even a lease with an option to purchase, that you may fall right squarely within that due on sale clause and give the seller the ability to call the loan, which is what you don't want to have happen. So make sure that if you are purchasing property subject to, and you're providing some form of wrap financing, which I recommend, that's the way I like to do subject to transactions, is to provide the seller with wrap financing. If you're doing that, you need to make sure that you don't have that due on sale clause, especially if your intent or you want the ability at some future time to do your own seller carryback financing. And then in addition to that, you need to make sure that the seller is made aware of it and executes or initials or sign some form of acknowledgement that they understand that their loan documents will not have a due on sale clause.